Thanks, Ron. That dovetails quite nicely with my opening comments on this topic. As a result of the Liberals' success last night, I think everyone in this room can expect continued and increased enforcement from inspectors with or without a badge in every respect. And so what I'd like to do today is not only touch on the points that are in the paper, which I commend to you for the technical aspects of the update, but I'd also like to add some practical advice and what I am seeing out in the trenches, so to speak, as to what inspectors are up to and prosecutors. So the first key update that I'd like to talk about before we get into the practical advice is a little new piece of legislation by way of regulation that might come as a surprise to some of you. It's designed to ensure a minimum amount of basic health and safety training for all workers and supervisors employed by all employers throughout the province, and it is effective July 1st of 2014. And I'm not sure whether or not a lot of individuals are aware of this new piece of legislation. It doesn't appear to have been given a great deal of publicity by the Ministry of Labour, but it is going to be effective in a few weeks. It's Regulation 297/13, and it's entitled Basic Occupational Health and Safety Awareness Training. Although the requirements are not incredibly strict, they are mandatory. The regulation obliges all employers to ensure that all employees receive basic training as soon as practicable. So obviously that timing is going to come in two ways. One, you either have this training accomplished before July 1st or as soon as practical after July 1st. And if you hire a new employee after July 1st, you don't have a definite time period set out in the legislation, but you obviously have a fairly narrow window of opportunity. The legislation doesn't say as soon as possible or forthwith, but the terminology of soon as practicable, in my mind, although it's not a defined term, would mean that you probably would have to ensure that it's done within a few weeks of hiring, no later than the end of the probationary period, I would suggest. The regulation has two components. One, it requires you to provide basic training for workers and for supervisors. If you can prove that the worker or supervisor received training at another employer, then you don't have to redo it, but you do have to have proof. And you have to keep records of the training that you provided to your workers and supervisors. The training that's required is fairly basic, so the regulation is not a misnomer, but I can see a lot of employers missing some of the ingredients if you're not careful. It's as simple as highlighting or training the individuals on the duties and rights of workers under the Act, and as we all know, the legislation has a section that sets out the duties of workers. You have to train them on the duties of employers and the duties of supervisors. You have to train them on the role of the health and safety representatives of the Joint Health and Safety Committee. You have to train them and provide basic information about the role of the Ministry of Labour and the Workplace Safety Insurance Board. And you have to provide basic training on common workplace hazards. So that will require some thought and some focus on what are the common workplace hazards in your particular workplace, so you can provide that basic training. And then supervisors, and I'm sorry, I just missed one. You also have to provide basic training on WMIS and workplace illnesses. Supervisors have to cover off all of those criteria that are required for a worker, plus a supervisor needs basic training on showing a supervisor how to assess and determine what a workplace hazard may be and how to fix it. And also, you have to provide basic training to a supervisor on the source of health and safety information. So all of this has to be provided to all employees by July 1st or fairly soon after July 1st. The records obviously have to be maintained for every employee. And if an employee leaves your company, the employee is entitled to ask you for a copy of their record within 6 months of their leaving. So each company is going to have to maintain a record of all the basic training that you've provided to everyone. Keep that in-house. So if you're audited by an inspector, you can show that you've complied with the law, and you can provide a record of the training to an employee who's left you for up to 6 months. So basically, that's the new piece of legislation that's coming down the pike fairly shortly. To just kind of blue sky for a second as to what this is going to mean other than the mechanics of actually accomplishing this training, which may be cumbersome for some employers and maybe easy for others. Obviously, a lot of employers have engaged in a tremendous amount of training over the last 20 years, and this basic training will not come as a surprise or an added burden to a lot of companies, but it's now a mandatory aspect that has to be complied with. The one thing that I can see that will impact most employers is if you have an accident and it involves an employee who has not received this basic training, either because you have failed to comply or you're in that limbo of being hired and not accomplishing the training quite yet, you are going to be in some trouble because the inspector is going to hold the lack of training for that particular employee or that particular supervisor against you. And it will play a large part in whether or not an inspector may or may not charge the employer or a supervisor with an offense under the Act, not necessarily for the lack of training, which obviously may follow, but also whether or not the company should be charged for a health and safety violation resulting in the accident. So I would urge everyone to ensure that you are complying or are going to comply with this piece of legislation, because it will have a very large impact on your ability to defend a health and safety charge if launched as a result of an accident, and will have a huge impact on whether or not you're going to be charged. It's already, as everyone can imagine, very, very difficult to launch a proper defense of a health and safety charge. The rules of the Health and Safety Act are mounted against employers. The rules interpreted by the courts make it virtually impossible to mount a due diligence defense unless you have every document in place in terms of due diligence, training, auditing, enforcement, etc. And if you're missing this component as part of that due diligence defense, I guarantee you, you're going to have a lot of trouble defending a health and safety charge if you are in provincial court. So this is obviously going to be very important in the next few years. On the topic of defending health and safety charges, again, this is something that's not in the paper, but I wanted to alert everyone to what's happening out in the real world. There is a definite change or increased focus on part of the ministry to enforce and prosecute employers. It's been increasing over the last 20 years to the point now where the ministry, given the political aspects of health and safety accidents, especially if there's a critical injury or a fatality involved, where the Ministry of Labor is charging and asking questions later. If there's any doubt as to whether or not an employer should have done something that resulted in an injury, then the Ministry of Labor, in my experience, is now filing charges, not just simply orders for compliance as a result of an audit or investigation, but they are launching charges because it's just politically easier for the Crown to basically put the information and the charges at the footstep of the judge and not take the political heat in pursuing a case or not pursuing a case. I saw that recently in a case that I was involved in, fortunately, successfully. It was a fatality that came out of a horrible accident in Waterloo. In 2011, an employee was acting as a swamper, which is basically a laborer who ties up equipment that's then taken away by a crane. And it's the job of the swamper to ensure that the piece, whether it's equipment or product, is tied off properly. When the swamper had performed his function, the crane operator was taking this 16,000-pound slab of concrete off a flatbed truck. The swamper asked the crane operator to stop the slab because he saw a piece of wood frozen to the underneath of the slab. And so the crane operator halted the progress of the movement to allow the employee to go underneath the slab and knock off this piece of wood. As the employee was walking back out of harm's way, unfortunately, the slab fell, crushing the employee and killing him. It was a very difficult case, obviously, and what you can draw from what happened is the seeds of our success in proving that the company was not responsible for this horrible accident occurred within about 10 minutes of the accident because the employer was proactive enough to phone and seek legal advice as to what they should be doing or not be doing that quickly after the fatality. And at that point, we were able to retain experts through our legal offices to ensure that any report that was produced was confidential and protected by solicitor-client privilege. We were able to strategize who the witnesses were, who should be interviewed, what documents and programs could be offered to the inspector to ensure that the company's best foot was put forward. And even though the company was able to provide a lot of evidence that they were not responsible for this accident, the Crown still filed charges, which led to a 7-day trial. And that's one of the reasons why I'm indicating that, especially with the Liberal government, the Ministry of Labor is on full alert to enforce and prosecute if there's any question whatsoever. And this case is a perfect example of that, even though the evidence was very sketchy that the employer was responsible for this accident. It appeared to be a crane failure, even though the crane had been properly maintained, et cetera, we still received charges. Fortunately, after 7 days, I was able to bring a motion for a directed verdict, and the judge agreed that there was no evidence to go forward with a defense, and we were successful in having all the charges dismissed. But the seeds of that success were in that phone call within a few minutes of the fatality, and the expert evidence that we were able to marshal to properly defend the case were very key and instrumental in the success. In terms of other updates that are going to be very important in the next few years, the Workplace Safety Insurance Act was amended to ensure that everyone has to pay and be covered by Workplace Insurance Act. And this applies in the construction industry. And as you probably know, the black market out in construction has been extremely active, and so the coverage of the act has been quite spotty. And so the ministry basically made it mandatory and decreased the amount of exemptions. The only exemption now in the construction industry is if an individual or company is devoted exclusively to home renovations. So there, the Workplace Safety Insurance Act is not mandatory. There's been a minor amendment to the Professional Engineers Act requiring that if an engineer would normally be required to give advice or stamp a drawing or some other device in the workplace, there was an exemption that a technician could give advice and give you specifications as long as the workplace was involved. Now that exemption has been deleted, and a professional engineer is now required across the board. There's been some notable cases that have come down recently. The most notable one being a recent case, again, a very tragic, horrible accident called Metron, where a number of individuals were on a swing stage, and this got quite a bit of press when it happened because there were a number of fatalities. And the reason it got a lot of press is for two notable reasons. One, the fines were increased by the Court of Appeal, and the company was the subject of a criminal negligence prosecution. As you know, I think it might have been about 10 years ago now that I spoke here about the new changes to the criminal code that made it easier for the Crown to charge individuals and or companies with criminal negligence. What we've seen over the last 10 years is a very conservative approach to this new legislation. There has not been a lot of activity. The Crown has utilized it only in those most horrendous situations, and this case was ready-made for a federal criminal code prosecution. The basic facts were there were 6 people on a swing stage that was really made for 2, so it was overloaded, and more importantly, the individuals did not have fall arrest. So when the swing stage failed, as it was destined to, because it was overloaded, the individuals fell to their death because they did not have fall arrest equipment. Not only did they not have it on, they were not even supplied with the fall arrest. And so as a result, the company and the supervisors were charged and convicted. At trial, the Crown was asking for an extremely high fine to take into account the awful aspects of this case, and the trial judge fined the company only $200,000. And the Court of Appeal rejected that, and in some stern language reversed it and awarded a $750,000 fine under the criminal negligence section. So the Court of Appeal over the last 5 years has made it very clear in cases not just like Metron, which is a very at the 10 out of 10 on the fact that the employer did nothing to protect the safety of its workers. The Court of Appeal has made it very clear that fines are going to be increased, fines are going to be substantial to ensure that health and safety is enforced and maintained throughout the province. And I, in my own practice, have seen a steady inflation of fines that are being asked for by the Crown and being awarded by the court. And so in a situation where 10 years ago you could plea bargain a case for a fatality in the range of $100,000 if there was no record, we're now looking at cases where the Crown is asking for $200,000 to $250,000. So just another, obviously, reason to make sure that you provide training and due diligence at all times to ensure that you're not in that awful situation. The one other aspect of the Metron case that is notable is that one of the charges resulted from the failure of the company to train the individuals in their native language. And I'm seeing this over and over again. So your typical situation is where the company has fabulous programs, training policies, properly executed, documented, people signing off that they were there, but very little ability to prove that the person understood what they just sat through. And so here I am, I'm preparing the case, and I'm interviewing people, and I might be interviewing the peer of the victim. And of course, I'm trying to solicit the fact that, you know, Mr. Smith and yourself, you know, you received training on such and such. And the individual will look at me with this blank stare, and I will ask the question again, and I'll ask the manager or HR manager, is there a problem? And I'm told, well, so-and-so's got some difficulty with English. Not only do they have difficulty with English, they don't even understand basic English. And so in this case, the company was actually charged with failing to ensure that workers could read English and received adequate instructions in English, and did not translate the training documentation into the particular language. And so it's very important in those workplaces where you have a very diverse ethnic demographic that your basic training is actually translated in languages that can be understood and comprehended by the individuals. And a lot of companies don't even think about it, and they just simply publish, get the documentation out, and just assume everyone's understanding it. Lastly, I would like to bring to your attention that there are a number of safety blitzes that are going on, not just this year, but last year and the year before. Every year, the ministry focuses on what they think are very situations where they're seeing a lot of accidents. So they then do a safety blitz attempting to deal with those issues. And where they're concentrating this year are on things like noise exposure, airborne substance exposure, WMIS, storage and movement of equipment and material, personal protective equipment, and administrative issues like ensuring emergency plans are in place. That is a very big pet peeve. That's not to say that they're still not interested with the key aspects that they've been dealing with over the years, and that is fall arrest and cranes. And those are still hot topics. The last update is on Bill 168. We haven't seen a lot of activity under Bill 168, which is the violence prevention program that was put in place a few years ago. And it hit the press just a little while ago, where the Royal Ottawa Hospital was charged as a result of a patient attacking 3 registered nurses at a nursing station. And the hospital has been charged with failing to develop and maintain procedures for summoning immediate assistance, failing to provide information and instruction to protect a worker from violence, and failing to implement safety devices and measures and procedures to protect workers from violence. Those are just charges. The case is going to be going ahead later in 2014, and it'll be very interesting to see what happens as a result of those charges. But that's the first case that I'm aware of where Bill 168 has formed the basis for charges under the Act as opposed to orders for compliance. Again, another little wake-up call that we've all done our Bill 168 training, et cetera, but it's not until something actually happens where you get the real test as to whether or not you've drilled down into your workplace and determined whether or not you've really come up with a plan to deal with workplace violence. So again, a nice reminder to ensure that you audit your workplace, ensure that you are up to speed, not just on occupational health and safety, but also Bill 168 and of course, WMIS, et cetera. And so I think I've run out of time, and thank you very much.